I'm assuming you'd prefer, rather than just go off on all the various evidence, that I address the concerns you've raised, because it would seem to be everybody's waste of time to do anything to the contrary. Keep in mind, we're talking about a case that was still in discovery phase. I had at one point prepared to get up here and argue we're not talking about someone who's been wrongfully convicted and stuck away in jail for a number of years before we find out someone has hid documents or hid agreements or whatnot. I would not feel completely sincere in making that argument after hearing Mr. Seligman testify yesterday, because in my 25 years of practicing criminal law, which is primarily what I do, I don't know that I've ever heard the description of the depths of being arrested and what just being arrested can potentially do to an individual in any case, much less a high-profile case. So I understand the damage that can be done for people who are just arrested and never spent a day in jail, potentially be as damaging for someone who's wrongfully convicted. And that being said, this case was, we're not talking about, in order to say that Mr. Nifong was intentionally hiding this DNA, would give some indication that he would never have a way of knowing this DNA could surface. For the panel to come to that conclusion, they would have to decide that when Mr. Nifong hears that information, he basically sits on that information with the, while he knows at that point he is against, one of the finest combinations of criminal lawyers in North Carolina or in the country. And that somehow, that these lawyers couldn't figure out a way to discover that information. I mean, when he hears that information, he hears it from Dr. Meehan. That information stays in the file. It doesn't go out of the file. It doesn't get hidden somewhere. Again, it's not like a statement that all of a sudden gets taken out of the file. It's hidden some exculpatory statement that would free an individual at some point. It is scientific documentation that is there for the world to see. It is there. Dr. Meehan knows, and the defense lawyers know the very next day they could turn around and ask for that DNA to be tested. So what you're asking to believe is that Mr. Nifong, who's been a career prosecutor for 28 years, and apparently an impeccable career prosecutor for 28 years, who has always engaged in open file policy, has always just given everything he wants, all of a sudden now decides he's going to hide a piece of evidence that he can't hide. And he makes no attempt to hide. He makes no attempt to have the documentation pulled out. He makes no direction to Dr. Meehan never to release that information. That information is open for the world to see. That information comes about when it's requested for individual testing, or in this case, when it was produced as a result of an order requiring underlying discovery to come about. Now, there's some issue about whether it's a report or not. Marcia Goodnow actually testified that could constitute a report. In the greater scheme of things, I don't think that's one of the more important issues before this panel. But he submits the entire documentation out there. Now, Mr. Bannon did great work. There's no way I could have discovered that information, and he's to be commended for the work that he did. But I don't know that it's all that unreasonable for Mr. Nifong to believe with the combination that had been put together, this wasn't going to be submitted to a DNA expert who also would have figured out that material, and according to Dr. Meehan, would have figured it out from his non-probative language. Of course,
what do you make of that?
I don't know what to make of anything.
In the report that he's holding certain non-probative.
I don't know what to make much of what Dr. Meehan said. I mean, if anybody can say they came out of a meeting with Dr. Meehan clear with what he meant on May 12th, my hats are off to him. Because I've never been clear from looking through all of his various documentation as to what he said. And according to Dr. Meehan, he said he informed, now Mr. Nifong did not come before you and say, well, gee, look at that language. I knew that what Dr. Meehan told me. Of course, that's what Dr. Meehan told y'all. Was that I informed him that this non-probative language meant we're referring to the unidentified DNA out there. And that anyone who looks at that would know that, and I was expecting a call the next day. Now, I don't know that he was really thinking that or not. That's what he testified to.
Well, of course, the term non-probative doesn't really sound like a scientific term. It sounds like a legal term to me. Where did he get that word?
Well, he said he came up with it himself, and we've heard nothing to the contrary. And we've heard non-inculpatory, we've certainly not heard non-probative during the course of various documentation. He said that was the language he came up with. He said it was a poor choice of words. He said everything in that report that he wrote was his idea. That no one told him how to write that report or limit that report or include or exclude anything. And he said that the language, I was looking through some of language from December 15th trying to make sense of it. He's all over the board. I mean, on one hand, he's saying at the end with some skillful questioning, he says there was an agreement. Other points, he said there was no agreement, that no one ever told me what to put in there. And then at the end, when Mr. Nifong asked him a whole series of questions, he says, no one ever told me, you never told me to limit the report or put anything less than the truth in the report, even though they had just referred earlier saying 3 would be truthful, but even if there was 12, it would be less than the truth. And the question was at that point, did you put anything less than the truth in there? And he said no. And in his deposition on page 123, that's in evidence as well, and he says, again, Mr. Nifong didn't limit to what I would put in the report. He wanted, at a minimum, my understanding. Yes, he wanted to know if there were any matches. And it was my intent to comply and show him the matches. And it seems to me the only discussions that were had with, you have the deposition of Sergeant Gottlieb up there, which makes no mention of any discussion of limiting a report. You've got Mr. Hyman, who made no mention of ever limiting any sort of report. And you've got Dr. Meehan, who testifies that the only discussion at all about, he never says whether we should or should not put the unidentified male DNA in that report. That's never a discussion. The only discussion you've ever heard about is whether to put the profiles of the 46 lacrosse players in there, because that would not be good. At this point, it's a high-profile case, and he doesn't want it out there. You look like you're ready to ask me a question.
Again to you, and I've said this to all counsel. I just don't think that this idea of what sort of agreement or discussion with me and as to a limitation on any report, or as to an agreement or a conspiracy or anything like that, I just don't think that's really very important to the issues in this case. And partially that's because our purview is not a general investigation of what happened here. We have no brief to decide what was in Dr. Meehan's mind or Linwood Wilson's mind or anybody else. We do have a mission to determine what was in Mr. Nifong's mind. And I know that you are a skilled defense lawyer, and I hear you talking about somebody other than your client. And I tell you, we're focusing on Mr. Nifong.
But the reason why we're talking about people other than my client is because that's testimony that was heard here this week in court and prior to that. And the reason why it was his testimony on December 15th that originated the complaint, that part of the complaint that brings us here today. And that's why we focus on that. Dr. Meehan is the expert. Dr. Meehan is the one charged with writing the report. And he testified, I would contend, he was never told how to write that report. So if something is excluded in their report, it's not because Mr. Nifong instructed him to limit that, but rather that was Dr. Meehan's choice what to put in there. For whatever reason, uses obscure language about non-probative evidence that I don't know that anyone could have actually understood, although he seemed to think he said it was he testified both in his deposition and on the witness stand today that non-probative language about other evidence specimens is consistent with industry standards and would show another DNA expert looking at that there were other DNA that was identified. And we've heard he said that in his deposition.
Well, that's another secret code language that an ordinary human being is not going to understand, I don't think.
That's correct, but another DNA expert would, and there's been no contradictory evidence placed by the state bar, who has a burden in this case, to show what he said is not truthful.
Well,
at least as to that point.
Let me just tell you, as to Dr. Meehan's testimony about anything,
right.
I don't believe that it's going to be decisive on any of these issues.